So yeah, let's just jump right into it for all my Floridians. We got here this news. So this is what I'm going to go over today. This is the Judge Mark Walker disqualifying himself from the DeSantis versus Disney lawsuit. So this is what we're going to be talking about. I'm going to go through the complaint. I have the actual complaint. So you're going to have a real Florida lawyer going through this complaint with you line by line and really picking apart, frankly, the judge's emotionalism. Because remember, the whole point here was that this judge was a biased judge who had frankly, a completely emotional, spastic, deranged reaction to DeSantis in general. So he's a person who is very anti-DeSantis, has ruled against him on pretty much everything that gets put before him. And I'm wondering if we should not come up with a new phrase. So we know there's Trump derangement syndrome, which is TDS. And that's definitely a thing. People like Legal Eagle, Leonard French, they have hard down with the TDS on YouTube. But I think we need to come up with DDS, DeSantis derangement syndrome, because there are people out there, and frankly, it's now on both sides of the aisle, on right and left, that are absolutely deranged when it comes to this. And just, they forget facts. And I'm okay if you attack people on things that are correct and good attacks. I think those are fantastic. Those are fine. If people want to come after DeSantis because he has crappy foreign policy or whatever else, or he doesn't know what he's talking about when it comes to foreign policy, he has a weird laugh, that's totally legitimate. I totally agree with that. But if it's something like Disney where it's just factually wrong, I want people to become better and I want people to learn the facts. I think if you're out there saying Disney's won, you're literally not even paying attention to this. You're not paying attention to this at all. This is a massive DeSantis W, and in that W, it exposed just how emotional this judge is, but it actually is even scarier because it exposes how these judges operate, how these extreme woke judges operate, and how they get away with bullshit time and time again. And we're going to highlight that today when we go through this. And shout out to Mexican Iron Man. He was one of the folks that sent this to me. He was not the first. Sorry, Mike, you were not the first, but he was one of the people that sent it to me. So thank you for getting that information to me. If you guys ever see anything out there, news on Disney, please feel free to forward it to me on Twitter. The Legal Mindset, always the best place to get information over to your boy. Locals is a good place as well, or Discord. So let's jump into it. So we're going to go right into the document. We're doing it raw. We're doing the complaint here. I'm going to pop in the corner and we're going to zoom in on this. So this is the actual case filing. So you guys can see I am not making something up. You know, this is not some sort of fake document. This was filed on the 1st of June. And this is in the case number 423CV00163AWMJF, which is this case, Ron DeSantis versus Walt Disney. Now, Ron DeSantis is not the only party. I want to be very clear about this. But the point of the matter here is that Ron DeSantis brought the motion to dismiss because of comments about Ron DeSantis. The other parties to this are all the board members of the CFTOD, the new district, as well as some Florida administrative officials. So Ron brought this because he's a party. He's entitled to bring that as a party, and you see that here. And the other parties could have also brought motions to dismiss in their personal capacity as well, or in the capacity of their entity that they represent. So Ron could bring something in his capacity as governor, therefore the state of Florida, and the CFTOD members, if there's any negative comments about the CFTOD, could also bring motions on behalf of the CFTOD. We'll get into all the other Disney stuff later, Jim. I've seen stuff on this, but we'll get into that after we get into the complaint. We'll talk about that later. In fact, I'll star your comment so we can look that up later. So thank you guys. And as always, this is definitely a live. Don, shout out to my moderator over there in Prague, waking up at 2:34 in the morning. Cheers. Hope you're doing well. Or if not, I'll just say, Dorbanok, have a nice sleep, brother. Anyways, so this is his response. So his order on disqualification. So this is Judge Walker, and this is Mr. Bowtie, the guy in the, this is the guy in the thumbnail, you know, Mr. Judge Bowtie. First of all, that bowtie should disqualify him in and of itself, but we're going to go on with that. And he is responding to Ron DeSantis' motion to dismiss. Now, Disney responded to that motion to dismiss, right? They said, oh, no, it's fine. They should not be dismissed. So here's the ruling on it. So I have considered, without hearing, defendant's motion to disqualify me. First of all, there probably should have been a hearing. So that's another thing. There's little things in here that come out. There should have been a hearing on this if there was actually substantial pushback. But that being said, ECF number 33 and plaintiff's response ECF number 43. For the reasons that follow, defendant's motion is denied. So he's coming out and saying Ron DeSantis' motion is denied. And mind you, he puts that in caps and bolds it, right? Saying, okay, the motion is denied, caps bold. Nonetheless, I find disqualification required for a different reason. He doesn't put this like, however, because I have a financial interest here, I am recused, right? He kind of minimizes the fact that he's going and maximizes the fact that he's leaving. It's exactly what Dr. No says here. You didn't fire me, I quit. That is some petty, feminine, emotional bullshit from this judge, which is exactly what you'd expect from a super woke leftist judge. You'd expect them to have the, it's not this, I quit. Like, what type of childish response is that? It's petty. It's a temper tantrum, thus the title. This is a legal temper tantrum where he's saying, you can't get rid of me, but I quit. Well, why would you do that? Before we go any further, let's just think about why you would do that. Yes, cue the emotional damage meme. Emotional damage. But why would you do that? You would do that for one reason and one reason alone. You would do that aside from his high estrogen levels, which you are very correct about. You would do that because you do not want to be a loser on appeal. All judges are frightened of being destroyed on appeal. And they know when they have a solid issue that they know they're going to be got on, they try to do things like this. We're saying, okay, I'm going to go out, but I'm going to go out my way. And let me point out why this is so important and why he is, yes, desperately trying to save face. It is because he could recuse himself all by himself. If he knew he was biased, he should have recused himself from the start of this. To wait until Ron DeSantis files a motion and then recuse himself, that is extraordinarily suspect. And it is extraordinarily petty. It's incredibly legally petty. It's the optimization of legal pettiness. You can recuse yourself at any point. You do not need a motion to recuse yourself. The judge can just recuse himself. In fact, many legitimate judges do actually just straight up recuse themselves. And that's what other judges do just when the case is filed. So the case is filed, right? Here's the procedure. The case is filed. The case is assigned to a judge. The judge receives the case. They look at the case. They say, oh, shit, I own stock in this company. Oh, shit, my wife owns stock in this company. Oh, shit, my third cousin Cletus has stock in this company. And they just recused themselves right away. He didn't do that. He waited until there's dueling motions, till all the press is on this, till he knows people are going to read this, until he knows that people are going to look at his biased framing, because all of this motion is going to be incredibly biased towards Disney. I'm just calling it. And by the way, guys, I haven't even read this motion in its entirety yet. I just got this. But I can tell you right now, the way he's going to frame things is going to be incredibly Disney biased. And he knows people are going to read that. It's going to draw attention to this. People are going to be quoting this in newspapers. So he's going to take a chance to take little jabs, right? Little petty jabs. So it's starting off bad. My hope for this is very low, just out the gate. And by the way, we've got 695 of you in the chat. Thank you so much. Appreciate you in the chat. Thank you, everybody. If you could smash a like button, there's 702 actually right now. We're at 194 likes. Let's get up to 350. We can do that. Tree Fitty. You guys owe me Tree Fitty. Speaking of a man who owes me Tree Fitty, we got Mexican Iron Man with a member chat here, which I'm going to post in the in the chat so you guys see it. It's my way of highlighting that. We'll read that out right now. Mexican Iron Man, who's been a member for a year, says 12 months of BLM, says like, share, and subscribe to this channel for up-to-date base coverage on Disney and more. Thank you so much, guys. We are at 98K. Thank you so much. Guys, we're at 98,000 subscribers. It only took us a hell of a long time to go up 8,000 subscribers from 90. I appreciate all of you. It's been amazing. It's been a great ride, and I love collaborating with people like Mike and other good people who are supporting this channel. And I want to thank everybody who's been out there with this channel, all the OGs who've been here from the beginning since the Rittenhouse days. I appreciate all of y'all. So let's continue here. So defendants seek to disqualify me from presiding over the case because, in their view, questions I have asked in previous related case raise substantial doubts about my impartiality. Yes, they do. ECF number 43 at 9. And I'm not going to read all the citations. I'm going to skip those. In response, plaintiff argues in short, the defendant's motion to disqualify is based on the misapprehension of the law and misstatement of facts. Which one? So let's just guess, guys, in the chat. Which one of these arguments are they going to agree with? Do you think he's going to agree with Ron's argument or Disney's argument? I wonder which one this judge is going to agree with. And I wonder which one he's putting quotations around. Come on. So he goes, under 28 USC 455, a judge must disqualify himself from any proceeding in which his impartiality might reasonably be questioned. So that's a pretty broad standard. If there's any reasonable impartiality, which I think they've provided, that's enough to disqualify him. Very low, but it's not such a high bar. It's not an amazingly high bar. Section 455 mandates disqualification only when an objective, disinterested lay observer fully informed of the facts underlying the grounds on which the disqualification was sought would entertain a significant doubt about a judge's impartiality. What matters is not the reality of bias or prejudice, but its appearance. So even the appearance of bias is supposed to disqualify a judge? Well, yes. Clearly, there are a significant number of people that believe that this appears to be bias. It's not just like, oh, this is an unreasonable thing. No, it objectively looks like bias. A reasonable person will look at this and say, this judge is biased. He just had an emotional DDS, DeSantis derangement syndrome moment where he splurted out in a case 2 years ago, 1 year ago, months ago, that, oh yeah, it's just like that Reedy Creek thing. That retaliation that DeSantis did to Disney. He just blurted that out. You don't do that unless you are emotionally damaged by DeSantis and have a resting bias against that position and for Disney. You don't just say stuff like that. It doesn't come from nowhere. When a judge harbors any doubts concerning whether his disqualification is required, he should resolve the doubt in favor of disqualification. So even he, in the cases he's citing, says, if there's anything, I should disqualify myself. Anything, even a small thing, you should assume, like I said before in my video about disqualification, you need to presume the facts in favor of the person filing the motion, right? Which is the defendant in this case, Ron DeSantis. So Ron DeSantis filed the motion. You need to take all the facts and you need to presume those are true. You can't take Disney's facts and say, oh, well, those facts are nice too. No, you need to say, okay, we're presuming those are true. We're ruling in light of favor of disqualification. And thank you so much. I want to get this reply by mail, 5 gifts. Appreciate you so much, reply by mail. You have been a homeboy hooking it up here with the gifts. Appreciate you. Let me star that out here in the chat. Thank you so much for gifting those 5 memberships. It really helps us out. Thank you. Welcome to the RPG. And also, those that are up there in BLM, appreciate you as well. Whether you're a member of the Replay Gang or the Base Legal Mindset, your membership is appreciated. It really helps us on this channel. It really helps us get by. I'll read these two. Breezy's Comics and Collection says, I'm going to need about 350. And Sam Gladden says, your power level is over 9 Disney thousand. I love it. Love it. Love it. Love it. I love my DBZ dorks, man. My old AIM screen name had Bardock in it, for those that get that reference, Goku's dad. All right, so let's continue. So we've established that this judge had a duty to remove himself from this case if there was anything, and I mean anything, that would have lent itself towards disqualification. So presuming all the facts in the favor, we should do it. He starts out by just straight up saying, defendant's motion is without merit. Okay? My use of hypothetical questions referencing facts related to this case in an earlier case also dealing with the motivation of political actors cannot raise a substantial doubt about my impartiality in the mind of a fully informed and disinterested layperson. I disagree. First of all, what he said was not necessarily a hypothetical. He stated it, at least in one of the cases, as a fact. He didn't say, well, hypothetically, in the Disney case, do you feel like there was retaliation there? No. He stated as a fact, the way DeSantis retaliated against Disney, he just stated that. He didn't say, hypothetically, or, pretend that I agree with that. No, he said it as if he fully endorsed that and agreed with it. It doesn't matter that he said it in a questioning somebody or asking a case. It doesn't matter that it was about political motivations. In fact, I think that makes it even worse. And once again, the standard is for a lay person. A lay person. A lay person means a regular Joe. It means you guys. So if any one of you guys thought that what he said was biased, he should remove himself. Not would a judge think that, or an attorney think that, or some douchebag professor from a liberal college. No, we're not talking about that. And sorry, guys, I'm fired up today. I know I haven't been cursing much on my streams, and a lot of people have thanked me for that. I do apologize. This just fired me up. I'm doing it live. When I stream, it's harder to hold back, guys. It's harder to hold back. This video has been a clip of a previous live stream, and it's clipped so you can get the information in a shorter, compact package, the information you need. If you want the full video, the whole context, the whole thing, you can check out the full stream. That is in the link below. Check that out, and I will catch you guys later. Peace.